Assalamualaikum warahmatullahi wabarakatuh, and a very good evening to everyone, and especially for our lecturer, Ustazah Azizun. So I will introduce myself first. My name is Patricia binti Muhammad Azadi from Group 7, and for today, our group will be presenting about the topic, which is about the issues and challenges in Islamic inheritance distribution in Malaysia. And before we go further, we are going to introduce myself, which is the presenter for today. The presenter for today, along myself, my name is Patricia binti Muhammad Azadi, along with my friends, which is Nur Azifa binti Muhammad Hanafi and Nur Izzat Natidah binti Nur Bini. Presentation outlines for today is we are going to see the first one, which is the history of Islamic inheritance distribution. The second one, we are going to see the administration Islamic inheritance distribution in Malaysia, and lastly we are going to see which is the main topic for today, which is the issue and challenges in Islamic inheritance distribution in Malaysia. Firstly, for the introduction, Faraid is an important branch of Islamic jurisprudence that can be defined as the Islamic law of inheritance or the Islamic law of succession, and this makes the Faraid as an important component of Islamic heritage possible. And Faraid can also be interpreted as the section of Islamic law dealing with the distribution of deceased person estate among his heir in accordance with all Allah subhanahu wa ta'ala history in the Al-Quran and according to the hadith, the tradition of the Prophet Muhammad sallallahu alaihi wasallam. Next, we are going to go to the history of Islamic inheritance distribution. For the history of Islamic inheritance distribution, it was divided into three phases, which is the first one is inheritance in pre-Islamic, the second one inheritance during the early period of Islam, and the last one is inheritance after Hijrah. For the first phase, which is the inheritance in pre-Islamic, prior to the advent of Islam, inheritance among Arab was asabah in practice, which is a male member of a family or tribe always was entitled to succeed a deceased member of such a family or tribe, and as a result, only males who were strong and capable of defending and protecting the honor of the family or clan were eligible to inherit, and women who had been completely denied the right to inherit under that principle. Not only were women denied the right to inherit, but so were the weak, elderly, sick, and minors. However, after the deceased's death, adopted persons and patrons, also regarded as family leaders, were allowed to inherit to the detriment of the deceased young children and other close relatives. This is the basis of inheritance during the period, which is nasab, blood relation, atabani, adoption, wala, which is defense respect, and nikah, which is marriage, which is favored to men only. The second phase is inheritance during the early period of Islam. Islamic law adopted the concept of asabah from the Jahiliyah period, as well as the Agnes priority rule, which determined who inherited to the exclusion of others. And the rule has been modified by Islamic law and is known as Jabaris. Instead of that, Islamic law not only increased the number of heirs eligible to inherit, but it also specified splits and distribute the shares to the respective heirs. The majority of the heirs are females, whose position has been elevated, and their social and economic interests have been protected. And the last one is the last phase, which is the inheritance after Hijrah. During the early stage of Islam, the Prophet Muhammad ﷺ established a system of temporary inheritance, which is known as Akhuwiyah, which is mean brotherhood in Islam. And some jurists interpreted the Prophet's action as being in accordance with the following verses from Allah in Surah Al-Ahzab, verse 6. This is Surah Al-Ahzab, verse 6, which is the translate, which is explained that the Prophet is more worthy of the believers than themselves, and his wives are in the position of their mothers, and those of blood relationship are more entitled to inheritance in the decrees of Allah than the other believers and the immigrant, except that you may to do your close associate a kindness through bequest. The natural relative of the Muhajir had migrated to Medina. Those who had embraced the faith migrated from Mecca and fought for Allah's cause with their wealth and bodies, as well as those who had sheltered and helped them were allowed to inherit one another, and this practice was discontinued when normal relations between Mecca and Medina were restored. Besides that, Allah subhanahu wa ta'ala abolished pre-Islamic practice of inheritance such as at-tabini, which is adoption as a ground of inheritance during Jahiliyyah, and also pagan custom which inhuman practice should be abandoned. Next, we are going to go to the history of Islamic inheritance distribution in Malaysia. Firstly, the practice of the Malay community in relation to the division of the property can be divided into three patterns of distribution. The first one is that we are going to go is prioritizing male heirs, also which is known as the patrilineal. Patrilineal is about prioritizing male heirs, entails giving them a larger share of the inheritance of making them the only ones eligible to receive it. Second one is prioritizing women heirs, which is also known as the matrilineal. Matrilineal is also about the giving preferences to female heirs when divided an estate, such as by allocating a sizable portion of it to them or limiting their eligibility to inherit it. The last one is prioritizing both heirs or bilateral parental. Bilateral parental is giving equal weight to male and female heirs in inheritance distribution, such as giving them an equal share of inheritance or equal rights. Islam arrived in Malaysia around the beginning of the 13th century, and thanks to the dominance of Shafi'i secular teaching, Imam Shafi'i teachings can be seen in inheritance practice. And although Imam Shafi'i teachings have had a significant impact on Malay society in the country, it does not provide a comprehensive picture of these influences as a full way of life to the Malay community. And depending on how eagerly family practice in respective religion, the following custom and religious teaching differ. It is because Islam is not fully integrated as a way of life in Malay society, and the blending of custom and law contradicts the demand for full implementation of Islamic law.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Azifah binti Muhammad Hanafi. My ID number is 2020987699. Okay, next I'm gonna present about the administration of Islamic inheritance distribution in Malaysia. Okay, next on this slide you can see there are 4 administration that are responsible to distribute the Islamic inheritance involving the Muslim, also non-Muslim property in Malaysia. So the first on is small estate distribution, and the second one is Amanah Raya Berhad, and for the third is a High Court, and last the fourth is Syariah Court. Okay, go for that. I'm gonna explain about the first administration. Okay, for the first is the small estate distribution. Okay, the administration of a small estate is governed by the Small Estate Distribution Act 1955 in Malaysia. The small estate distribution manage the property case of Muslim and non-Muslim involving small estate comprising either immovable or a combination of immovable and movable assets, whereby the amount is not more than 2 million ringgit. Okay. Next, the point is the eligible person can apply by filling in Form A and submitting several documents, include death certificate, burial permit, and document related to the property of the deceased, as well as property certificate. Form A must be submit all the estate distribution unit or land office where the deceased immovable property is located. Okay, for the second administration is about the Amanah Raya Berhad. Okay, Amanah Raya Berhad, as we know, is a trust company that was established under the Public Trust Corporation Act 1995, incorporated under the Company Act 1965, and started operating as a company on 1 August 1995. Okay, Section 17 of the Public Trust Corporation Act 1995 empower the corporation to issue either a declaration or a direction order to the beneficiary for the purpose of estate distribution. Okay, the corporation jurisdiction is rather limited in terms of monetary value, and thus it cannot administer asset worth more than 60,000 involving movable property for Muslim and non-Muslim. Also, ARB serves another important role in estate administration. It is by acting as a personal representative on behalf of the deceased beneficiary upon appointment made either by the estate testator or by the court. As well, in this case, has open requests made by all beneficiary. Okay, next is about the High Civil Court. Okay, the High Court has jurisdiction to issue letter of administrative authority and disposition order for property value at more than 2 million ringgit, whether combined or separately. The High Court may also hear appeal under Section 29 of the Small Estate Distribution Act of 1995, which the Probate and Administration Act of 1955 govern the situation. And then there are two types of letter representation which can be granted by the High Court, namely the grant of probate for testate case and the letter of administration for intestate case. Okay, for the last part of administration is the Sharia courts. Okay, Sharia courts handle the case of determination of heirs and the share of each heir issued in the faraid certificate. It is based on the State Islamic Religious Administration Enactment or the Islamic Law Administration Act, Federal Territory 1993 Act 05. It is told that the Sharia court only play a role in issuing foreign certificate and is referred when there are collateral issue in the management and administration of property. Also, Sharia court is governed by the administration of Islamic law enactment or administration of the religion of Islam. Also, for the point is the jurisdiction of the Sharia court is very limited and not as broad as the jurisdiction available at the federal level. In addition, the Sharia court has jurisdiction in matters related to will, grant, waqf, legitimacy of children, marriage, conjugal property, and lineage, all of which are closely related. Even the decision of the Sharia court relate to the above matter affect the division of inheritance. Okay, next is the has regard to the deceased Muslim estate. Sharia court only deal with minor jurisdictions such as determine the share allotted to the beneficiary under Islamic law and issue of faraid sigil upon the request of the civil court. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. And hi, my name is Nuzati Nadira Binti. I will continue this presentation. Let's we go to the issue and challenges in Islamic inherited distribution in Malaysia. First, we go to the issue. The issue is dual court system, no total authority over the administration and distribution of Islamic inheritance. And the last issue is the length and costly producer to handling the inherited distribution. We go to the first issue. The first issue is dual court system. In Malaysia, as we know, we have two types of court because Malaysia legal system is divided into two types of court, which is civil and Sharia court. Civil court are established. Civil court are established under Article 121 of the Malaysian Constitution and dominate the large part of the Constitution. Hence, all Malaysians are subject to this jurisdiction. jurisdiction. Sharia code have been established by the state, and this code administers Islamic law only on Muslims. Okay, the second issue is no total authority over administration and distribution of Islamic inheritance, where although Islamic law are stable law, this not give Sharia court complete control over the Islamic inheritance. So, the Sharia court does not have the authority to administer or issue or any order related to the division of inheritance. Also, the management and the administration of Muslim estate in Malaysia is distributed to the three main agencies, namely High Court, the Division of Small Inheritance section under the Minister of Land and Mines, and lastly Amanah Raya Berhad. The Sharia Court only has the role of using foreign certificate and is consulted when collateral issue arise in the management and administration of property, such as the issue of legality of marriage, confirmation of heirs, and the right of heirs. The third issue is the land and costly procedure to handling the inherited distribution, which is any transaction or application in turn cost. This may play a significant role in beneficiary refusing to follow the appropriate process and had to spend a lot of time and money before they could realize their right. Also, intensive method to research the matter of their estate may take years, resulting in an episode of frozen estate difficult and delay in the settlement period. The third issue is the land and costly procedure to handling the inherited distribution, which is any transaction or application in turn cost. This may play a significant role in beneficiary refusing to follow the appropriate process and had to spend a lot of time and money before they could realize their right. Also, intensive method to research the matter of their estate may take years, resulting in an episode of frozen estate difficult and delay in the settlement period. Next, we go to the challenges in Islamic inheritance distribution in Malaysia. First, we go to unawareness of the client, where there are many customers and the community do not know the correct process and procedure in claiming their inheritance right. There is confusing about starting a claim, where customers do not know where to start, continue, and where to go to make a claim. Also, they are also not aware of the need to hire a lawyer in certain cases brought before the High Court. The next challenge is the attitude of the beneficiary. This is because there was a big fight in claiming the inheritance. Also, they're not having patience in dealing with also give a big challenge and greedy attitude. This will interfere with the process of managing the estate due to the received attitude. Last but not least, the challenge here is unclaimed inheritance. Back to the first challenge, where the occurrence of unclaimed inheritance is due to the level of awareness of property management is low among the people. Lack of planning to serve it is also the cause. This is because without proper planning, implementation will face problem. Planning cannot be done well without knowledge of related process and procedure. This is because in order to take action to stop the problem of troubled property, he also need a management course. Conclusion. The conclusion for this presentation is, from the history of Islamic inheritance show there are many changes from inheritance in pre-Islamic until now. Like in Malaysia, there are 4 administrations in managing inheritance distribution, namely first, small estate distribution, second, Amanah Raya Berhad, third, High Civil Court, and the last one is Sharia Court. However, there are issues and challenges that need to be faced in implementing the division of inheritance. One of the issues is the length and costly procedure, where time and cost are as the two main parameters that need to be considered to ensure smoothness throughout the process. The challenge is an awareness of the client. So, the client awareness regarding the division of inheritance also need to be improved so that the challenges in managing it can be overcome. That's all from us. Thank you.